А что с презентацией делать? Привет. Hello.
Hello, everyone.
Welcome to our webinar. We are glad to see you again, friends. We are glad to see that you are watching our webinars again, that you are with us, and you are so curious about the GDPR again. So it's great to see and great to hear. So today's topic is Estonian GDPR and GDPR in general, and I'm so glad to tell you that I have a guest today. We have Olga. She will tell us a little bit more about the Estonian GDPR practice. So there are a few words about me and about our speaker. So Ola, would you like to tell us a little bit more about yourself?
Hello everyone, greetings from Estonia. I'm Olga. I'm co-founder and chief legal officer at Cybersecurity. We are an Estonian startup, and we provide comprehensive privacy and security services. I have background in law and background in IT. And I like to call myself privacy wizard because I specialize in GDPR, and I can help your company to transform from non-compliant to compliant.
So great. I'm so glad that you are with me today, so we can give our watchers a little bit more insights, maybe valuable insights about the GDPR in practice. So actually, my name is Kateryna. I'm working as a head of GDPR department here in Legal IT Group. I'm also a lawyer, and I have a master's degree in international private law, but I'm really curious, and I'm really engaged in working with the IT, with contracts, with privacy, with GDPR, with European frameworks, and so on and so on. So it's so great that we have our boss today. Ola, I've heard you have been writing a master's thesis about the GDPR. Is it right?
Yes, that's correct. And I wrote my master thesis about applications, privacy, and security. It was very interesting. I enjoyed writing master thesis really a lot.
Well, it was quite interesting because my master thesis was also focused around the GDPR, but I was writing about in general and applications in the international private law. So it's about my focus in the master's. So I guess we have a little bit insightful expertise.
Awesome.
So a little bit about our agenda today. Would you like to introduce it to our listeners?
Yes, sure. Today we'll be talking about general scope of GDPR for IT companies, what IT companies need to do. We'll be talking about specific GDPR regulation for Estonian IT companies, what's special about Estonia. And also we will be talking about tips and tricks, how to fast implement GDPR for your IT company in Estonia.
Not only in Estonian, but also in Ukraine, and if you are working with Estonia in the Europe in general. So I think that you will get some maybe useful insights, some useful tips, and some useful advice from this webinar. So write us, but first write us about how do you hear us? Is everything okay with the connection? Can you comment? Can you write what is happening? Can you follow our webinar also? Is it okay? Please write in the chat, and also you can ask any questions you have during the webinar. We will be glad to tell you a little bit more and maybe share some delicious information from our own experience, from our own practice, so you can have the most of it. So there is the agenda, and I guess for those who might miss a little case we have published in our Facebook page yesterday, here is a summary of the case. So you can imagine that you are a founder of an Estonian IT company. So you are surprised to learn that all your friends from the latest networking event are already compliant with the GDPR, but you hear about it for the first time. And while you are Googling it and assessing the necessity to ask your backup team, like what are we going to do and what have we have to do, you have a thought that why not register a Ukrainian IT company and just pretend that it is the main office, the head office, deciding on matters related to privacy. And in this way, how do you think? What would your lawyer say to you? please write about it in the chat, and we will see your answers soon enough. But now, while we are warming up, while you are connecting to our webinar, we'll start. And the first question is the scope of GDPR compliance that your company might need. And what is the thing? Why we are starting with this? We can give you some. I will give you some little advice, some start from which you can jump into the GDPR. And in this way, I've searched a few red flags, few points of special attention. And while I'm talking, Olga may also accompany me and give you some practical advice on there and there, so you can enhance your knowledge and see what is lacking. Okay,
sure.
Shall we start?
Sure, sounds good. Yeah, let's do it.
So, any updates? Okay, so we'll start with the basics. We will have to understand what data we have, what personal data we collect, what personal data we process, who our data subjects are, and where we shall start. And in this way, we are deciding on the essential matters, like what personal data we have. Is it HR data or non-HR personal data? Of course, this is a matter of special importance because you have also your employees, you have also your contractors working abroad, or maybe in the European Union, within the territory of the European Union. So in this way, you have to understand which data you have, which data your HR department has and can process. And while this matters, because some IT companies forget that they are collecting not only the data of their clients, of their users, of their applications, of their website visitors, but also they have a vast amount of personal data on their own employees. And in this way, they can meet an awful, maybe not awful, but uncomfortable surprise that they are lacking the compliant in this area. And when you have decided that you have two kinds of personal data and you have to address them both, you should understand who is your monitoring national authority. If you're working in the European Union or the market in general, you may see that you're working with several jurisdictions, and in all of them having their own national authority. So you may address the problems that you can't understand which is your lead authority. And in this way, you should first you understand which data you collect, and then you understand who is your leading authority. And the framework that this leading authority produces is also mandatory to you. After that, we are thinking about our product. What are we selling? Are we selling a product, just like a good? Sometimes IT companies also produce some physical goods, and not always. It's actually occasion, but sometimes it happens. And in this way, they also may have mostly it's a software as a service and another kind of service, and both of them should be addressed with a GDPR problems in mind and matters in mind. And in this way, we shall understand: do we have all the by design, by default options available to our users? Like, do we have privacy by default, privacy by design within our product? Was it designed with the privacy in mind? And if not, we have to address it and maybe change the architecture, or maybe change the way our service is rendered or performed. So it might be understandable that we as an IT company care about our users' privacy. Ola, do you have any cases in mind that required actually the changes in the architecture, maybe in the software, addressing the privacy in mind, privacy by default?
Well, every company needs to follow this rule. I'm just thinking about what can be an example. Well, let me think about it, and maybe we can talk about this in the end of our
Great. So I have one more question.
Yes, maybe yes, maybe you can present something, Kate.
Okay, I have one more question. Was in your own practice, was it your problem to understand which is the leading authority of a certain IT company?
Well, in case of Estonia, everything is pretty much clear because it's defined in national regulation. So it's not, in Estonia, it's not the case, basically. Pretty clear. But I know that there might be the case, yeah.
Yeah. So one more question, and we are proceeding. Do you have any experience working with internal DPOs, or maybe you have been appointed as a DPO?
Yes, I have experience as a DPO. I've been helping startups to be GDPR compliant.
Mm-hmm.
But mostly I work with startups and small companies.
Okay,
that's what I'm specialized.
So can you please tell us a little bit more about what the DPO does? What is his or her responsibilities and duties on day-to-day basis?
Okay, so you have to, as a DPO, you have to make sure that company is GDPR compliant. So you have to be specific about data that you collect. So you have to follow whole process. As you Kate mentioned before, you have to take care not only about data from your customers, but also from your employees, how you handle those data, why you collect those data, what is the legal basis for collecting those data, and then you also need to delete data if you don't need them anymore, if you don't use this anymore, and you don't have legal requirement to keep those data. That's important. Mapping data is
a must.
Yes, it's a must. Mm-hmm. Also, legal documents that you have to have proper documentation, not only external, like privacy policies that you post on your website, but also internal documents. You need to have guidelines for your employees, how to handle data for their everyday job. So that also
it's an essential
must.
Yeah.
That's essential. Yes, you must do it.
You must care for the knowledge and the awareness of your own employees and contractors. Yes.
Definitely, and you need to make sure that you follow all technical requirements and that your employees are aware about cybersecurity, and employees must be trained. So it's also important to have regular updates about what is going on in the company.
By the way, it's actually a frequent question, like what is the privacy, why it is different from security, and sometimes we have to explain just really simply that security and privacy are not the same in basics. Like security is carrying from the security for the security, like meaning that the protection from cyber attacks, from leaks of data, all the data, from leaks of passwords and so on, and privacy is more about human rights, maybe more about not the technical side, but of the people side, I guess.
Yes, it's definitely correct, but I would also add that both are important, like legal perspective and technical perspective, and they work together. So both need to be included
to produce a perfect result. Yeah.
Definitely.
So you mentioned the internal documents, and two of them are the most important, actually, is the privacy policy, general overarching all the activities of the company, and the data protection impact assessment, of course, because you can't access what data you need, how long you have to store it, how much of it you really need, if you don't know what risks are associated with it. And in this way, the data protection impact assessment is mandatory for all the companies before they start any processing activities. Am I right, Olga?
Definitely, yes, that's correct.
Sometimes it may be a quite challenging task to conduct it properly, but it is all about the result. In the result, you have addressed most of your risks, and you are ready to start activities, start to surfing in the market and talking to your customers and clients. Some of them are pretty nervous about their personal data. So actually, it's not about the formalities. It's about the care and about the attention to what your customer, what your client, and what your employee needs. So in this way, all the internal documents are mandatory to you. So you can show that you are pretty much accountable for what you are doing. And in this way, you can show your care and show that they are not all about only you. It's about customers too. It's about hearing their thoughts, hearing their meanings, hearing their mentions about you, and having this proper connection with those who are buying and who are caring for your product too. And so, Ola, you wanted to say something?
No, just wanted to say that exactly, you're absolutely right, and it's essential. Yeah.
Yeah, so great. And after you have conducted all the research, you addressed its risks, you decided how you will mitigate them, you have to care for the internal relations of your company. This is not a surprise that most of IT companies are seeking for outsourcing jobs and outsourcing work outside of the European Union as well, and not all the countries in the world are covered with the adequacy decision. So it's okay that sometimes we have some contractors working from abroad, from countries that are not so progressive with their data protection laws. And in this way, you have to address it somehow, and somehow respect your users' rights to privacy that are enshrined in their own legal framework of their own country. And in this way, we have to structure our cross-border transfers of personal data. It can be made with several instruments like bidding corporate rules, some standard clauses, maybe some other technical or other measures, but most of them, and the frequency of them, is actually data protection agreements, data processing agreements sometimes. And what are they designed to do? They are designed to create a similar framework of duties, of obligations and rights between you as a controller or processor and your controller and processor respectively. So the personal data is covered and is protected with the highest level of obligations, mutual obligations as possible. And in this way, we have several jurisdictions that are more easy to work with without the DPAs or with lighter frameworks of them, like the US, whereas Privacy Shield is working, and the Switzerland, where the similar Privacy Shield is adopted, and the adequacy decision countries. Some of them, like Canada, or like for example, Norway, and so on, and some others, are covered with adequacy decision adopted by the Commission of the European Union that are saying essentially that the framework, the legal framework, legal acts, and legal atmosphere in those countries are the same as in the European Union. So the users can give their personal data to those jurisdictions without pretty much concern. And of course, in the end, when you have conducted all your research, when you made all the documents you need, you have to also address your own country of residence, count of jurisdiction, count of registration, of domicile, national acts like national legal ordinances in this way, the requirements of your own national authority, and in this way you have to make not only every effort to be in compliance with the GDPR, but with your own legal acts as well. And with it, for example, how do they impact you may ask? It's more about the differences between the GDPR and the areas where the countries can introduce their own rules, like the age of consent for minors. Some of them are adopting 13 years border, some of them are requiring the user to be at least 16 years old, like Germany. It's about the GDPR black and white list of operations that are requirement, data protection impact assessment or not, and about some particularities of the legal basis to be adapted when you're processing and collecting data from your users. And you may ask why it is important. Why is it so important? What is about the GDPR is? Is it about some special techniques to obtain? Yes and no. You can see that there is an unofficial course statistics about the fines issued under the GDPR and under the national protection rules. And one of the greatest concern from all the companies not to be compliant only on the paperwork. It's about the changes in your own approach to business activities too. So the first line is devoted to the insufficient technical and organizational measures to ensure information security, and you see that the sum of fines is just devastating, I guess. And second, the most popular, not the most popular, but the most important issue you have to address on time and as soon as possible is a proper legal basis for your conducting of your business. After that, you can see that mostly the companies that are most affected are giant companies that are not so quick to quickly responding to changes. And in this way, it's important to understand that you have to keep some level of flexibility to address privacy and be proactive rather than reactive. Am I right, Ola?
Of course, yes, it's definitely correct, and it's important to think about privacy and security ahead.
Great. So I was mentioning the national particularities. Would you please tell us a little bit more about how the things are in Estonia?
Yes, I will continue with specific regulation in Estonia. So there is some specific requirements in Estonia, and I will start with Estonian Data Protection Inspectorate, which is the most important body for GDPR compliance, and this organization is basically responsible for consultation and also for giving fines for companies as well. And what is really cool about this organization that companies can go for advice to DPI, to this inspectorate, if they have doubts, if they are not sure how to implement GDPR, so they can contact this body and ask for it.
So may I have a little question just to make it clear?
Of course. Yes, of course.
So the functions of the leading authorities, of the national authorities, is not only to impose fines, but also to consult. Is it right?
Yes, that's what I'm saying.
So if you have any doubts, if you have any concerns relating to how you process your data, you may just write a letter or maybe an SMS or a tweet to your national authority and just ask without any fines involved?
Exactly. You can contact DPI to ask how to be compliant, because the main task is not to punish people who are doing something, companies and people who are doing something wrong, but also to help them become compliant. So that's very important. So it's we all understand that GDPR is complicated, and become GDPR compliant is also it's a process, and it's a complicated process, especially for companies that are new in the market. And sometimes it's also quite complicated to do it by yourself. And if something is, let's say, not clear, companies can contact DPA to help them, basically. So
that's great, actually. It's maybe reassuring to hear, but because sometimes people are just too afraid to ask, maybe.
And I think Estonia is really cool country for this, because you can open contact governmental offices. Basically, if you need something, if you need help, and they are very helpful and supportive. And also, I would like to notice that statistics of fines in Estonia is much lower than compared to other countries. So it means that this organization try to help people more than punish them for doing something wrong. So as you can see, it's only 46 precepts and 9 fines.
So it's quite a low number.
Yes, but it's also the biggest country itself is small. But yeah, the main idea is to help become compliant. Well, GDPR itself is it's not just about fines. It's more about it's about data protection. So just putting fines to companies doesn't make any help, but becoming compliant is a goal. And also about Estonia, that in addition to GDPR, we also have a special national regulation, which is Personal Data Protection Act. It's pretty similar to GDPR in terms of in terms of requirement, but it also has certain specific requirements. So it's also a little bit different as well. Like for example,
is it right in plain English? It's important.
Sorry?
Is it written in plain English? It's important.
Yes.
So the law is GDPR compliant, yes?
Yes, I would like to say that, GDPR is pretty difficult to read. As for me, as a lawyer, even, it's pretty complicated language for understanding. And what is really good with the Estonian Data Protection Act that it put the same regulation in a bit more simple words, so it's easier to understand, even for regular people, not lawyers. So it's much easier, and it also gives some specific regulation, like provision of processing data for journalistic purposes or scientific needs, and historical research and official statistics. And also providing information of society services directly to children starts from 13 years. It's very specific for Estonia because Estonia is very information technology oriented, so it's important that children from quite early age can have access to their own data, which are digitalized, and they don't need to ask for specific permission from parents. They can do it directly.
So I assume that the National Act is just addressing the topics as well, not only them, but as well those topics that are neglected in the GDPR to be maybe more in light.
Yes, and I would say in opposed to GDPR, Estonian national law, Personal Data Protection Act also specifies some things. Like, for example, if we are talking about data which are large-scale processing, which are not defined in GDPR in specific numbers, it is defined by Estonian DPI, and in Estonia, if we are talking about large scales, it's defined in specific numbers.
By the way, we have a slide you have provided us with big data according to Estonian DPI. So please tell us a little bit more about it.
Okay, so the big data is in specific numbers. So if it's special categories of personal data or data about criminal records, so the scope is 5,000 plus people. If it's personal data of high risk, is 10,000 people. And if it's other personal data, it's 50,000. So now you don't need to have doubts if your data is it large scale or is it not large scale. Now you have specific numbers, and just have a look if you fit into these numbers or not. And if you do, and it depends if it's large scale, if it's big data or not. Your GDPR compliance also depends on it.
Great. So, Ola, I have a question for you.
Sure.
It's a question from our listener.
Okay, great.
Oksana asks you that do you in Estonia have complaints regarding Trumbita?
Regarding Ukrainian system,
what is Trumbita and how it impacts Estonia?
Okay, so as far as I know, Trumbita is a Ukrainian system, and I'm not sure about if we have any complaints regarding Trumbita because it's Ukrainian, so so I haven't heard of any cases. Well, I know that Estonia basically helped Ukraine to develop IT systems.
Well, it's a great example of international cooperation, I think.
Yes, it is. But I wouldn't say that there are any complaints.
Well,
it was bought from Estonian.
So, okay. For those who are not reading the chat, Trumbita, as Oksana says, Trumbita was bought from Estonia for e-government. So it's kind of a system to work with the data. Of course. Okay.
Yes, so, I would like to. I would like to add that it was maybe it was not exactly bought from Estonian government, but it was implemented in cooperation with Estonia. So it was created, as far as I know, it was created by Ukrainian companies.
So this way we have some.
Estonia just implement.
In this way we have some, I guess, access to the free market of the European Union, at least in the case of personal data, I see.
Yes, and Estonia is really like to cooperate with other countries, with Ukraine as well. But everything was much easier to implement in Estonia because Estonia is small and Ukraine is much bigger, and everything in Estonia is digitalized. And but in Ukraine we are also going there to digitalization.
Also, we have a question from Alexander. He asks whether Estonia has fined anybody for breach of the GDPR. I guess we have covered it already a little bit earlier.
Yeah.
Maybe it was just for a reminder. There is the little statistics about 46 percepts and only 9 fines.
9 fines.
Yeah. So it is official. I have not addressed any inquiries in, for example, GDPR tracker. But I assume that you can see them in the DPI statistics, yeah?
Yes, DPI publish annual report, and you can you can read this report. It's available not only in Estonian but also in English.
So it's accessible to see, yeah.
Yes.
So thank you very much. It's actually quite insightful information. To see the experience of other countries to addressing the GDPR and the privacy in their own countries. So this proactive activity of the leading authority is quite wise, I guess. So I guess we will give our listeners a little bit tips and tricks. Yeah.
Yes, we can continue with.
So you have mentioned that IT companies shall map their data. Why is it so important? What is mapping of the personal data?
Yes, so mapping is very important because companies need to understand what data they have, and also think about clients' data and think about employees' data. Sometimes people, like companies, if they provide software, they might think that they don't even have any personal data, but in fact it's usually not, because at least they have employees. So and it's also important to keep in mind those. So mapping data means that you basically visualize what data you collect and what is happening with those data. So you provide like a full cycle of data.
Okay.
Kate, would you like to add something to mapping
I
data?
think
Maybe some tools how you do it?
Well, the tools are different. They're including even a sheet of paper and a pencil, of course, on the first
Exactly.
stages.
That's very handy.
Yeah. Especially when you are asking your own clients about how they process their data, is always a lot of paper included, actually. So in this way, mapping the map of the personal data, of its flow, may be conducted and may be presented in various ways, from purely technical things to just a plain sheet of paper and pencil, of course, because some of this mapping must be presented in a form that is accessible to the eye, to understandable for a plain person as well. For example, sometimes you have to address questions regarding the privacy with your HR department, with your legal department, with your sales department, and so on and so on. And those people are not always so progressive in terms of IT, in terms of coding, in terms of maybe creating some databases, creating some maps of logs, and so on and so on. So in this way, some of the data must be presented in the plain view. So even the plain lay person who is working with their own area of knowledge, because the HR and the legal and the sales are, of course, as important as others departments in the company. So in this way, there is nothing to avoid. You have to present it somehow to make it accessible to laypersons. And mapping of data. Yeah.
Sorry, I just wanted to add that in Cyberwise we are working on digital tools that will help companies in like easy way to map your data, like how you collect them and what is going on with data. So we are thinking about how to build a very intuitive tool. So if our listeners have some tips and suggestions for us, how you would like to see it, we would like to hear about this. We would like to read about your opinion about mapping data. Maybe you have some ideas that will help us to make like better tool for our users.
Our feedback or suggestions, yeah. You can write it to the chat, you can write it to our mail, you can write it to Cyberwise. You will see the contact details in the end of the presentation, so you may access both of us as Legality Group, and we will connect, of course. Or the Cyberwise is likewise, it's up to you, but you can start with writing to chat. Just writing your questions, maybe writing your suggestions, and so on and so on. We will be very, very glad to have a feedback from you, to see that you are with us and you are hearing us and listening to us. And who has to map this data, Ola? I see that we have written that we are addressing the need to appoint a DPO. So just for a reminder, who the DPO is?
Okay, so DPO is Data Protection Officer, and it depends if you need to appoint DPO. Mapping data would be the main responsibility, one of the responsibilities of DPO. You can have DPO as your employee, or you can also outsource Data Protection Officer. So it depends on your company. If a company doesn't have DPO, it's still important to map data, and it also depends. There is no specific person who needs to do it. Like, for example, if there is chief of legal department, it might be this person who will map the data, or if company is like, let's say, small, CEO may also do it. So it's just important to have all your data collected in one place. But yes, if you have DPO would be the person who does the job.
By the way, I think Ola will agree with me that there is always a confusion who is responsible for the GDPR in the company as well. They are thinking that if a company has a DPO, he is the only person who is responsible for the GDPR compliance of the company. It's quite a popular misconception, I see. And most in all the cases, the person who is mostly responsible for the GDPR compliance in general, for its implementation in the company, it's actually the head of this company. So in this way, the DPO is not the last person. He or she has to advise before taking any actions relating to privacy, relating to the collection of personal data. Is it right?
Yes, Kate, I absolutely agree with you that DPO is not the person who is who's responsible. Well, DPO is responsible in terms of doing his or her job. Like, they are responsible as employees. But if company is fined, DPO is not the person who will pay the fine.
Who will be reversed, yeah.
Yes.
So we have also a question. I guess it's for both of us. How, yes. And Alexandra Krasovska asks us, how and which companies are chosen for the expansion? Is it random? How do you think, Ola?
Well, there is also random check. Yes, that's correct. But also, if someone complains about companies, like let's say if I'm as a person not happy with some services, yeah, that I received from some company, and I can complain to DPI and say that they violate my rights, and after that DPI can contact this company and make this check.
So essentially what we are talking about is that it's not only you as an IT company who is the first contact in case of any questions or any concerns related to the privacy activities and routines in your company. It's so good it may be DPI as a first contact. They might lodge a complaint with the DPI not addressing you directly. So in this way, why it is important to protect and respect privacy is just because of this mechanism of that enables the data subject to seek protection not only with your own employees, who may so well ignore or not notice on time the request or the complaint, but also the DPI as a first point of connection, with first point of telling their concerns as to related to their privacy and their human rights in essence. So this system aims to protect the data subject as well as to make the companies actually to proceed with privacy-directed decisions when they are addressed to the well-being of their own company. And so, why is it so important, and why there must be a privacy directed in mind, is because you have to address them first of all in your own product, in your own service, and in your own internal documents. Every move, every decision, every thought just related to privacy, related to personal data, it's collecting, it's processing, it's storing, and so on, has to be reflected in the internal documents and be specific, meaning that we have this piece of data, and we use it for those purposes, and we may store it for as long as there is provided in the document. Sometimes it may be addressed as the longest work, as the work that asks for the biggest point of intention, of effort, of expertise, of course. But in the end, it's actually rewarding. It's rewarding work because you know how data are processed, how you addressed, who has access to those data, how the roles and responsibilities are divided into between the employees and between the contractors, and you may control and manage your data. But what means the transparency in external documents? Why transparency is so important?
Yes, I would like to say that transparency in external documents is very important. That, for example, if you have a company and company website, and you need to be very specific, clear, and transparent about data that are collected. If you use cookies, you also need to have specific documents that provide users information about what data are collected, why they are collected, how they are used, to whom those data are shared, and when they are deleted. So it's important to inform users about usage of their data.
So if I have, let's say, 200 pieces of cookie files implemented through our site, do I have to write everyone?
You have to have one document that will cover basically everything, but cookies are also different. Let's say there are, if in your cookies you have you collect personal data, you need to ask for consent. If it's connected to social media or like something like this,
like Facebook, I guess, yeah.
Exactly, like Facebook, LinkedIn, or others. It's definitely that you need to inform users about this. If you have cookies that are not personalized, like for example, if it's language settings, it cannot identify you, like if it's not combined with any other information. So you don't need to ask consent for this specific cookies. But if it's personal data, or if it combined, like let's say, if you collect small pieces of personal data that each piece by itself cannot identify person, but if they are in combination and you can identify person by combining all those data, it's considered as personal data. So it's important to keep in mind and be transparent about this as well.
So transparency, in essence, means that we have to reflect everything that we do with personal data in our documents accessible to the users and to the employees. Am I right?
Yes, I would say that, yes.
So, should transparency also include the accessibility? I mean that do they have to be like understandable to the lay person, to the persons who are not so good with IT things, like IT staff? And,
definitely, it needs to be written in, let's say, human readable language. So you don't need to let's say your regular user need to have opportunity to understand the language, how it's written. Because like if we compare older privacy policy to modern privacy policy, the older are like before GDPR, they are so confusing and they are so not transparent, and it's just only general phrases, and usually they are very long and they do not give specific information to users what is happening with their data. And now it's changing. This approach is changing, so it's getting better, which is really, really positive.
It's for the best, I guess. Yeah.
Definitely, yes.
It's so hard to read sometimes the privacy policies of certain services because they are so long and so written in legalese, not understandable to the layperson, not having the law degree. So sometimes I can't forget the thought that what they do, how they're coping with it, it's how they're dealing with it. It's so so hard to read, so
Yes.
so dry, so the text is so dry and so uninteresting.
And also some companies, they just copy paste privacy policy from other companies or from template, and they think that it will be enough for us, but it's actually not, because privacy policy, well, as well as other documents, they are very personal, and they need to they need to show they need to tell users what exactly is going on in your company, not in some general like type company.
It's just still like an artist approach. So you are saying that it must be tailored, and meaning it's tailored means that you as a controller or as a processor working on behalf of the controller and imposed with some responsibilities to collect data, shall collect only those data that are really necessary to perform your job. Meaning that you not have all the data used for other purposes that the user is not aware of. Meaning that if you have collected the data to perform any service, for example, to deliver subscription content, to give some functions like to maybe to access to other people for networking, it just depends on your own service, on your own product. You're not able to use those data for other purposes that you have not thought about, that you have not taught your users about, that they will use, and not obtained the consent if in case of direct marketing, for example. Some of users are really uncertain to use several services, several apps, because in the end they will be maybe just dealing with the vast amounts of spam emails, of spam notifications, and so on and so on. And this is really what stops them from the digital economy maybe sometimes. That I don't want to receive a lot of emails from you guys, so I won't use your service. I will go to the local shop. And in this way, of course, it's also a red flag for some marketing teams, I guess.
Yeah.
So, but what about the updates? Why do we need updates related to privacy?
I would say updates are important because it's not like you're doing the same services all the time. Like, for example, if something changed in your company and you collect, let's say, more data, or you add some additional services, you need to update your privacy policy. You need to update your internal and external documents. You also, I would say, updates also include awareness updates. So if some processes are changed in the company, they need to be employees need to be updated about those changes and how they need to behave. So that's important. And also, I would say updates is important for software, for software in terms of security perspective.
Yeah.
Let's say if security measures were implemented, security measures were good 4 years ago. It provides nothing like now. There will be like no security if you implement all security measures.
Oh, so, I see. The technology changes, and you have to adapt to new way, to new, not the fashion, but to new challenges in cybersecurity too.
Exactly. So update for security software is also important. So it's like two parts: legal updates and cybersecurity update.
Yeah. That's the edge we are working on, right, Olga?
Yes, that's our expertise.
Yeah.
And also, we would recommend you if GDPR and technical measures. We understand that it might be too much for one company, and if you want to focus on your business, on developing your business, not only on thinking about privacy and security and checking if everything is done, we can we can provide services like GDPR compliance and cybersecurity compliance to help you stay safe.
Yeah, so use help of professionals, I guess. Oh, sorry.
Yeah.
And in the end, I would like to introduce you a little case to think about. And while you are thinking about the case, we have 2 more questions, and we would like to address them. But first of all, we have this case of Cripsand dating app.
Mm-hmm.
I don't mind the name. It was totally made up. So suddenly, sometime between the productive branch and meditation, of course, you need some time for meditation. You were stricken by the idea to create a perfect dating app. You have heard that some of them are not secure, some of them are not so safe for users. So you decided that you will help people, providing with them with safe service. And it's going to be intuitive, because useful, specific, simple, and so on and so on and so on. But in the end, it actually connects your user with their perfect soulmate, with their sweetheart. And you decide to provide it for free, meaning that maybe it's not a service in this way, maybe it's just a function you may encounter in the internet, not a service. And you just plan to collect some data and then use it to build. Actually, it's just a charm. You want to use it to build a strong privacy-oriented mailing service, for example. So this dating app is just an experiment, not something really serious. Just to try something, to collect some more data for statistical and actually scientific research for your R&D team. How do you think? Will your lawyer proceed with your idea? What would he or she say to you? And will they agree or maybe disagree, and why? And what decisions he or she would ask to implement before starting any dating app? Write to the chat. We are waiting for your responses and for your ideas how to proceed with this idea. But right now, I have 2 questions for you, Ola.
Okay.
So the first is, Alexandra again asks us, can DPI find not Estonian companies that collect data from Estonian residents? Have you maybe encountered some cases or have heard about them?
Okay, that's actually very good question.
So I guess that it's not really quite a popular decision from the DPI.
Yes, I think basically if company located in let's say in other country, let's say in other EU country, it will be, and it violates some rights. It doesn't really matter if it's Estonian residents or other EU residents, but if a company belongs to a specific country and it will be fined, or it will be like contacted to the country like body that is located in this country will fine this company. So it's I think it works this way. So if it's Estonian company and Estonian citizen, it will be fined by Estonian DPI. But if it's in other countries, it will belong to other countries.
So there is a related question from Oksana. She asks whether we know Estonian companies which have branches in Ukraine, and do you know, Ola, about EU officers on data protection in Ukraine? Meaning officers. I guess the DPO mentioned is or not. Oksana, please write us in details. What do you mean by EU officers? Meaning the employees of the sub-branches, or DPO assigned from the European Union working remote, or what do you mean? So, Estonian branches in Ukraine? Have you heard?
Estonian branches in Ukraine? Actually, I don't. Usually, Estonian branches are in Baltics. I know about strong cooperation. Like even our today's webinar, I would say it's a strong cooperation between Estonian and Ukrainian company.
Yeah.
Yes, and I really hope you liked it.
A lot.
And I know about cooperation on governmental level. like Trumbita is one of examples. In public transport, there are those validation like for cards where you can swipe your card. We also have the same in Estonia, so it was also made like influenced by Estonia. I would put it this way. So I would say it's more like cooperation, not that some company will Estonian company will establish some filia or like Estonian company.
As for me, what have I heard of is that some countries, some European countries that have branches or offices, maybe affiliated companies in Ukraine, they actually have the overall GPO overseeing all the group of companies or the mother company and the subsidiary, and they have also maybe a DPO, the local DPO employed in this company or working with this company. So they are just helping or addressing the privacy decisions that and implement them on this local area to this, especially this company or some companies that are in Ukraine, but with the DPO, with the chief DPO residing in the country of origin. It's the cases I've heard of. And sometimes some companies are just engaging the outsourcing DPO companies or just a DPO on a contract basis who is following the few companies, for example. Because in essence, we should not forget the DPO is an advisor. It's not a person who takes responsibility for the overall GDPR compliance and is personal responsibility. He advises. And this advising obligation, this some kind of immunity from the overall responsibility is actually a guarantee of their that they are actually, how to explain, that they are independent from the company and from the decisions taken by the CEO or maybe CFO and other people who are actually thinking first of all about the business, not about the privacy. And in this way, the DPO has to be independent in meaning of obligations, in meaning of their actually cost of their services, and so on and so on. And this immunity from responsibility is like a warranty that they can make impartial decisions related to privacy in the company and make the advice as useful as possible. One last question, and we are proceeding with the case. It's about GDPR provision to have GDPR offices in non-EU branches of the EU companies. Well, we partly have covered this. So, Oksana, thank you for your questions. Actually, it's quite interesting because how people work with DPOs and privacy officers is always complicating its issues because you never know what is better, to have as an employee, to have as a contractor, to have an outsourcing firm. It's always up to company, I guess. Is it right?
Yes, I would add this. I would answer the same. So it depends on the company, and yes, you can have one DPO for several companies. You can outsource DPO. So it depends.
So several DPOs if you can afford it.
Of course.
An employee and outsourcing, why not?
The more the better.
Yeah. The merrier. Yeah. So, what about the case? We are still waiting for your responses. Maybe we give you a hint or two. So, Ola, just for a reminder, there is a dating app, but it's not used as a primary focus of business. It's just used for for the research purposes. And in this way, maybe the GDPR still applies, even if it's traded for free. So the main focus of your attention shall be how deeply the company will be affected. Not the company, but also the privacy of this certain app is affected with the privacy decision made with privacy in mind. So I'm waiting for your responses in the chat. Ola, maybe you have a hint for our listeners too?
Yes, I have a hint. I would focus on precise match, and you cannot really have precise match without specific data. So I would think about which data needs to be collected and start thinking from this point.
Yeah, starting with it.
Yes, and after that, I will think about research and how this is done.
So
we're waiting for your responses.
Yeah. So we have heard the questions. We are waiting for more questions in the chat, in the commentary section, to our maybe mailing posts for us Legal IT Group, for Cyberwise. Ale is representing here. So we are waiting for your questions. Feel free to ask us whatever is bugging you related to privacy, and we will help. We will try to answer you as promptly as possible. So, Ola, thank you a lot. It was just a pleasure to have this webinar with you. Thank you for all your insights and for your additions. It was quite resourceful.
Thank you, Kate, and it was a pleasure from my side as well. It was my first webinar, and well, I think it went very well.
You nailed it. Yeah.
I hope you all enjoyed, and well, thank you, Kate, and thank you, Legal IT Group.
A couple of words about your company, maybe, just for a reminder.
Yes, so we are Cyberwise. We are Estonian startup, and we provide comprehensive privacy and security services. We can help you with GDPR compliance, like if you need DPO or if you need help with technology solution like encryption, or if you want to provide cybersecurity or privacy trainings, or both for yourself and for your employees, we will be very glad to help you with this. And yeah, so feel free to contact us. Here you can see our website. We are also on social media, or feel free to send me an email. So we're waiting for you to contact us. Thank you. Thank you for your attention.
From Cyberwise. My name is Kateryna Dubas. I'm representing the Legal IT Group, a legal law firm based in Kyiv, Ukraine. We can help you also with GDPR requirements. We can draft your internal documents. We can help you with mapping your personal data. So feel free to ask us for help or consultation. We are going to be as open as we can, so we can provide you with the highest level of service possible. Thank you, Ola. I hope you have a new webinar coming soon. So stay tuned. Bye.
Thank you, Kate, and thank you, listeners. Bye-bye.
Bye.